Today, we're digging deep underground for a tale of mining safety, patent warfare, and one very blue piece of mining equipment that sparked a legal battle all the way to the Federal Court of Australia. Welcome to Jusand Nominees vs. Rattlejack Innovations, the case that sent Australian patent attorneys into a collective panic, clutching their specifications like security blankets. Imagine this: you're working deep in an underground mine. Above your head are drill holes stretching 60 meters up, each stuffed with broken drill rod sections weighing up to 500 kilograms. That's literal half-ton metal rods dangling over you like the world's worst game of Jenga. Except if you lose, you become a pancake. When these bad boys fall, and they do fall, they hit with an impact force of 67,000 kilograms. That's 67 small cars landing on you simultaneously. Side effects may include sudden compression, an urgent need to update your will, and becoming a cautionary tale in future mining safety seminars. So naturally, someone invented a solution. Jusand Nominees came up with an elegantly simple concept: stick something in the hole to catch the falling rod. They christened it Safety System and Method for Protecting Against a Hazard of Drill Rod Failure in a Drilled Rock Bore, something that just rolls off the tongue, and got their Australian innovation patent. But then Rattlejack Innovations rolled out their competing product, a large blue plug-like contraption called the SafetySpear. Jusand took one look at that blue SafetySpear, thought, that looks suspiciously like our patented invention, and did what any self-respecting patent holder would do: they sued. The case landed before 3 federal court judges and centered on Claim 1 of the patent, which described a safety system with an anchor member and an impact reduction member. The anchor member was supposed to be configured to be fixed in a proximal end region of the bore adjacent to a rock face. Patent speak for positioned near the entrance of the drill hole. But here's where things got rocky. Could the anchor member move when struck by a falling drill rod? Or did it have to stay put, like a good little anchor? Jusand argued their anchor could move down the borehole when hit, like a brake. Rattlejack argued that an anchor, by definition, should stay anchored. After examining the specification, the court concluded this particular anchor could move only a few millimeters. Any more, and the whole system might fall out of the borehole, defeating the purpose and likely leading to the pancake situation described earlier. So how did the SafetySpear measure up? Well, this is where Jusand's case started to look a bit fractured. The SafetySpear had 3 plastic expansion rings as the anchor member, but there was virtually no experimental evidence about how they behaved when struck. The only evidence came from drop tests at the Karasu Dam mine using a prototype that was different from the actual product. The testing methodology involved, and I'm quoting the court here, a painted line on a long stick. The photos were blurry, and even the tester admitted it was hard to tell whether the device had moved. Justice Parham noted this might detect movement of half a meter, but was completely inadequate to establish movement of 5 millimeters, the crucial measurement for infringement. Result? Jusand failed to prove infringement. But wait, there's more! Even if they'd proven infringement, their patent was invalid anyway. Jusand's patent claimed a safety system that could be made from various materials: steel, plastics, fiber-reinforced polymers. But the specification only really taught how to make it from steel. To make it from other materials, you'd need prolonged research, inquiry, and experiment, figuring out materials that could withstand 67,000 kilograms, then designing for their different elasticity, compressive strength, friction coefficients, and melting points. The court drew an analogy to a UK case called Regeneron, involving genetically modified mice that could produce human antibodies. The essence? You can't claim a monopoly over a range of products if you've only invented one specific implementation. In Jusand's case, when you're catching a 500-kilogram projectile at high speed, the choice between steel and plastic isn't cosmetic. It's fundamental to whether the thing works at all. The court found Jusand's patent was like claiming to have invented the automobile, but only teaching how to make a horse and cart. They'd grasped the brilliant concept, but only solved the engineering problem for steel construction. Result? Patent invalid. No infringement. Jusand loses on all counts and pays everyone's legal costs. The moral? If you're going to claim your patent covers a broad range of embodiments, make sure you can actually teach someone how to make them all. Blurry photos and painted sticks can't support infringement measured in millimeters. And sometimes, the most brilliant ideas only get you partway there. Jusand had genuinely solved an important safety problem, but they'd only solved it for one specific implementation. Before the court could settle whether the SafetySpear infringed, they had to drill down to the core question. What exactly makes an anchor an anchor? Thanks for watching. And as always, keep imagining.